Hello and welcome to another video essay on international law. In this video expose, I shall discuss the ruling of the Permanent Court of International Justice on the Panevezys-Saldutiskis Railway case in light of the rules concerning diplomatic protection. After a brief summary of the facts underlying the case, I shall analyze the court's decision and its impact on the interpretation of the rule of national claims, as well as raise some questions regarding its negative consequences. The case started with an application filed by the Estonian government against Lithuania owing to the refusal of the latter to recognize the proprietary and concessionary rights claimed by an Estonian company in respect of the Panevezys-Saldutiskis Railway, which had been seized and operated by the Lithuanian government. As can be noted, Estonia availed itself of the Institute of Diplomatic Protection in order to take up the case of one of its nationals, in this situation, a company. Lithuania, however, objected that a state's prerogative to ensure diplomatic protection to one of its nationals is limited by specific conditions, one of which is a rule of international law according to which a claim must be national not only at the time of its presentation, but also at the time of the injury. Therefore, Estonia would have to prove that by the time of the alleged violation of international law, the aforementioned railway company displayed Estonian nationality. The notion of diplomatic protection is well known in international law. In broad strokes, it establishes that a state has the prerogative to take up a case of one of its nationals by resorting to diplomatic action or international judicial proceedings on their behalf. As can be seen in the famous Panevezys case, it is in fact a legal fiction, built upon the classic understanding that states are the major, if not the only, subjects of international law. Thus, any violation of it would necessarily have to be traced back to a violation of a state's rights, even if the true victim of the tort were actually a private actor. As such, one of the main conditions for exercising diplomatic protection is that there must be a bond of nationality between the state and the individual which seeks protection, so as to ascertain which state had indeed their own sovereign rights violated by the tort committed against their citizen. This rule, although generally accepted, raises some questions, since this bond of nationality is not always permanent and can change under some circumstances. What would happen then if an individual's nationality changed after the violation of their rights? What implications could that have when it comes to diplomatic protection? In the railway case, Lithuania argued the existence of a rule of international law demanding that a claim must be national not only at the time of its presentation but also at the time of the injury. In other words, the bond of nationality would have to exist from the time that the injury was suffered by the individual up until the moment that the sovereign state presented the claim. Let us see then what was the opinion of the court on the matter and which consequences it entails. Although the court did not rule whether or not the railway company had the Estonian nationality at the time of the injury due to procedural reasons, it stressed that Lithuania was right in maintaining its interpretation of the rule of national claims. Thus, it supported the thesis according to which the bond of nationality must exist from the time of the injury to the presentation of the claim. Which, however, are the consequences of such interpretation? It can be easily noted that if this thesis should prevail, unjust situations could arise. Let us examine, for instance, the possibility that a certain individual which had their rights violated by a sovereign state and met the general criteria for the concession of diplomatic protection changed their nationality after the incident which led to the injury. In this situation, this individual would have no chance to receive protection by the state of his prior nationality, much less by the state of which he is now a national. This dire possibility is a mere reflection of the problems that arise when the Panevezys fiction is taken to its full extent. When diplomatic protection is read as a tool designed to protect a state's sovereign rights and not the rights of individuals, the loss of the bond of nationality after the injury implies the loss of any protection conferred upon the individual, since no state can henceforth claim to have had their rights violated. When it comes to international jurisdiction, this issue has, as of yet, not been solved. This has been another video essay on international law. I hope you have enjoyed it. If you have any thoughts, let us know in the comments. And as always, don't forget to subscribe if you'd like to see more. Thank you, and until next time.